Your custody order says medical and extracurricular expenses get split evenly, right? But your ex hasn't responded to a single request in 3 weeks. Or maybe a DC Superior Court judge just told you in mediation to start using a co-parenting app, and you have absolutely no idea which one actually counts as evidence if this whole thing goes back to court. This explainer covers exactly which co-parenting apps DC courts actually recognize, what each one costs, and how to use one so your records hold up if a judge ever has to look at them.
Now, you might be wondering, which co-parenting app does DC Superior Court actually require or recognize? And does it even matter which one I pick? It's a completely valid anxiety. You want tools that hold up as actual evidence. Picking the wrong one means you might as well be writing your expenses on a napkin. You absolutely need a platform that generates a true court-admissible record.
Well, here is the hard fact. DC Family Division judges order OurFamilyWizard in roughly 60% of high-conflict custody cases. Courts treat it as the default standard for documenting expenses, communication, and reimbursements when parents simply cannot manage on their own.
So, to guide you through this, here is our roadmap. 1. DC court-recognized apps. 2. Evaluating the app costs. 3. Solo mode and uncooperative co-parents. 4. DC child support thresholds. And 5. Logging admissible expense evidence.
Okay, Section 1, DC Court Recognized Apps. Let's talk about the tangible benefits of using these approved platforms over scattered text messages. The data here is really compelling. Parents using structured app-based tracking actually see roughly 65% fewer financial conflicts than parents managing expenses informally. Plus, they return to court about 40% less often. These apps essentially eliminate that chaotic he said, she said dynamic.
Moving right along to Section 2, evaluating the app costs.
Look, the immediate real-world question is always, how much is this going to cost me every year, and is there a cheaper option that still counts in court? It's totally understandable. Mandated software can be an unexpected burden, so we need some absolute cost clarity here. Pricing varies sharply. OurFamilyWizard runs from $149.99 to $299.88 a year per parent, depending on the tier you select. AppClose, which operated for free since 2016, now charges $8.99 a month. Meanwhile, budget alternatives like DComply cost between $36 and $72 a year, providing the exact same court-admissible record formatted in a way a judge will accept. By the way, if you want the full breakdown of what each of the 5 DC-recognized apps costs and which one fits a budget case versus a high-conflict one, the full article is linked in the first comment below. Section 3, Solo Mode and Uncooperative Co-Parents. So, what happens if your ex simply refuses to download any app? Can you still document expenses without their cooperation? It is incredibly frustrating to deal with one-sided compliance. You pay the fee, you set it up, and they flat out refuse to participate. Well, that is where Solo Mode comes in. It's a feature that allows one parent to send requests via standard text or email. Even if your co-parent completely ignores it, the app automatically generates an unimpeachable, court-admissible record of your compliance. It legally protects you by proving you did your part, regardless of what they do. All right, Section 4, DC Child Support Thresholds. Now, a question I hear all the time. Our combined income is over $240,000. Does that change how child support gets calculated? The answer is a resounding yes. Hitting this specific threshold fundamentally shifts the legal landscape. Here is what happens when combined parental income passes $240,000. DC support calculations stop following the standard guideline formula. Instead, they shift to a discretionary calculation. This means a judge decides the amount case by case, rather than just plugging numbers into a set formula. In these discretionary cases, your exact expense documentation becomes absolutely vital evidence. Which leads us to the structural question regarding physical custody time. How many overnights actually shift my case from joint to sole custody for support purposes? That number is 128. If overnights drop below 128 a year, which is under 35% of the time, the calculation shifts entirely into the sole custody support formula instead of the joint custody one. Every single scheduled overnight matters. Finally, Section 5. Logging admissible expense evidence. You need to know, how do I categorize expenses so a judge accepts them if my ex disputes a charge? Making sure your digital records are actually usable in a courtroom dispute is absolutely crucial. DC judges expect rigid behavioral rules here.
First, set specific expense categories early. Second, log purely logistical facts. Keep the emotion out of it entirely. And third, respond within 72 hours. Even if it's a formal dispute, DC judges expect a response within that strict 72-hour window. You cannot just ignore it. Ultimately, the app you pick matters less than how consistently you use it. Unemotional, logistical consistency is your ultimate protection. A perfectly chosen app is totally useless if you only log expenses when you're angry. If you want to see exactly how DC judges expect expense categories logged so they hold up as evidence, including fee waiver options if the subscription cost is a barrier, the full article is linked in the first comment below. Subscribe if you want more DC family law guidance like this without having to search for it every time. So think about this. If you are called into room JM300 tomorrow, would your current expense records look like a clear financial ledger or a chaotic, emotional text thread?